Merchant of Richards, Leighton and Finger on behalf of the debtors. Your Honor, before getting to the one matter that is on for the agenda today, I just wanted to update the court. We referenced an extension of the challenge period at the last hearing. Just wanted to alert the court that we are in the process of filing a proposed stipulation and order under certification of counsel today in that regard. It will actually extend the challenge period through June 6th, and the details of that extension are set forth in that stipulation.
All right, thank you.
With that, we filed an amended agenda this morning. The only matter remaining on the agenda is the debtor's letter request with respect to the scheduling of the hearing on the trustee motion. That's agenda item number 16, and Chris Harris from Latham and Watkins is on and will be handling that on behalf of the debtors.
All right, Mr. Harris, go ahead.
Thank you, Your Honor. Just for the record, Chris Harris of Latham for the debtors. We're here on our request to put off the hearing on the Haviland Hughes plaintiff's motion for appointment of a trustee until confirmation. They set the trustee motion for a hearing on June 9th, which is 3 weeks after they filed their motion. And that's a date on which we already have 2 contested lift stay motions scheduled, and the Haviland Hughes plaintiffs separate motion to lift the preliminary injunction, and 2 other matters that may be contested. It's also just 1 day after our disclosure statement hearing, and it's just 2 days after another hearing where we expect to have several contested matters, including several related to Axar. So Humana's estimation and administrative claims motion, our summary judgment motion in our adversary proceeding against the city of Rockford, our objection to the Axar related class proofs of claim, and our omnibus objection to unsubstantiated claims. And needless to say, these all involve a lot of briefing leading up to them, and most of them involve substantial discovery as well. So given all that's going on and trying to make the issues in the trustee motion be handled in a coordinated and efficient manner, we propose to have the hearing on the trustee motion occur along with plan confirmation. We're happy to have the motion decided, but there's no emergency justifying that it be rushed and decided now. The first point I'd like to make on this, and it's briefly touched in our letter, is that the motion primarily raises confirmation issues, such as the allocation of value across the mallinckrodt entities, whether the plan was filed in good faith, whether the plan unfairly discriminates against the Axar plaintiffs or claimants, whether our current Axar pricing gives rise to administrative claims or is illegal conduct in violation of the bankruptcy code, and other matters that are on their face confirmation objections. The trustee admits that they're confirmation issues. And in fact, they say that, I'm sorry, I said the trustee, the Haviland Hughes plaintiffs admit that these are confirmation issues. And that's one of their reasons for appointing a trustee, they say, because we're proposing an unconfirmable plan. So I just wanted to talk about what practically that means and whether it makes sense to try and decide these issues in 2 weeks. So, for example, they say in the trustee motion that the Axar creditors are being treated unfairly, differently than other creditors. That makes the plan unconfirmable. But if Your Honor were to decide that issue in June in the context of the trustee motion, how would that work? If you reject their argument, are the Haviland Hughes plaintiffs now barred from raising that argument again at confirmation? Or how about the other Axar creditors? Are they barred? Is the committee barred? Is everyone barred from making that argument later? If that's the case, then everyone needs to step up now and litigate these confirmation issues in the next 2 weeks. Or if that June decision doesn't bar anyone, then does the estate have to bear the cost of litigating the same issues twice? Once in June and once at confirmation. And even if that is that case, is everyone still going to feel the need to litigate things in full now just to avoid poisoning the well by a bad preliminary ruling? That's just one example, but there's lots of other examples of issues that they raise that other creditors will be interested in and will have arguments for and against, and will be raised at confirmation. So disjointed litigation over what are fundamentally confirmation issues with different parties at different points in time, it's not fair to the litigants, and it's certainly not in the interest of the estate, which is going to have to bear those costs. So consistent with that, it's not surprising that courts have found that when there's arguments for a trustee that are actually confirmation objections, they should be decided at confirmation. That was in, one example is INRI WorldCom Inc., which is 2003 WL 239666765, the Southern District of New York bankruptcy case. So that's the first point, is it's not practical to try and decide these confirmation issues now. The second point is also a practical one, which is discovery just leading up to a hearing is going to be a heavy lift. More than 2 weeks are needed, and it needs to be coordinated with the other parties, with the other creditors, and with the committees. So the Haviland Hughes plaintiffs have demanded extensive discovery, a lot of which duplicates discovery that they and others are going to seek in confirmation. So just focusing on the documents, they asked for all documents and communications regarding valuation of the entities, how those values were determined, how value was allocated. All documents regarding the financial statement and the assets of each and every Axar entity. All communications between the debtors and everyone about the RSA. They've requested all documents about intercompany transfers and value allocation, and all documents about classification and treatment under the plan. And they demand that all this stuff be produced immediately so they can then take equally broad 30B6 depositions. So other parties are going to want documents on these same issues or related issues, and we need to coordinate those requests. Even if there was a way to do it in 2 weeks, which there is not, it would be inefficient to do it now and then have different overlapping requests later for confirmation purposes. That's just documents. They also want depositions. They've asked for the personal depositions of our CEO, Mr. Trudeau, and our COO, Mr. O'Neill. But other parties wanted to depose them too, and on related issues. The committees have both said they wanted to depose them, and they would tell you they are not ready to do so. They've not even requested their emails yet. So is everyone going to be forced to rush the one and only personal deposition of our executives next week? Or are these witnesses going to be forced to sit twice for a personal deposition? And then the Haviland Hughes plaintiffs has also asked for a variety of 30B6 topics on things that are clearly related to confirmation, such as the subject matters included in the plan of his organization, the financial projections, liquidation analysis, and valuation analysis, the valuation and methodology for each of the debtors' business units, the determination by the debtors of separately classified unsecured creditors. People are going to want to take these depositions on these topics again. So June 9th is in 2 weeks. It's not enough time to permit the parties to develop the comprehensive factual record that's needed to resolve the issues that they're raising. And there's no way to coordinate this with the similar, if not identical, discovery that people will want in the confirmation process. So I do want to be clear that the debtors do intend to provide discovery to the Haviland Hughes plaintiffs on these issues as soon as practical, regardless of the hearing date. We've already produced over 100,000 documents to the Haviland Hughes plaintiffs. We're producing hundreds of thousands of more emails to the committees that we will provide to the Haviland Hughes plaintiffs. And we have told the Haviland Hughes plaintiffs we will treat their trustee document requests and their disclosure statement document requests as confirmation discovery, and that we will handle them and expect to produce many more documents to them through that process. But it's important that the discovery and the issues be coordinated with the issues that other people want discovery on as well. It's not possible to conduct proper discovery on all these issues now, and it's not efficient to do that either. The last point I'd just make on this is there is no emergency that justifies rushing this motion. The Haviland Hughes plaintiffs say that this is urgent, but their actions make it clear that it's not. They filed their original trustee motion on February 1st, but they didn't even want it heard right away. They scheduled a hearing almost 60 days later, and then they withdrew their motion. Then they waited another 90 days to refile that. None of that reflects a sense of urgency. And to be clear, the central allegations in the first motion are quite similar to those in the renewed motion. They both argue that the Axar claimants are being unfairly discriminated against, that the debtors engage in mismanagement before and after the bankruptcy filing, that we're committing consumer fraud every day because we haven't repriced Axar, that there's excessive professional fees and conflicts of interest. Those are all arguments that were made before. Their main new argument is that pursuit of the plan would be a waste of resources because it's patently unconfirmable. But that point is going to be decided by the court at the disclosure statement hearing, which is scheduled for June 8th. And it's not even clear what urgency the Haviland Hughes plaintiffs feel at this point. Their letter no longer asked that the motion be heard on June 9th. They just asked that it be heard before confirmation. So if the court decides that the trustee motion should be heard before confirmation, we will obviously find a way to do that. But discovery needs to be completed first. It needs to be coordinated with the rest of confirmation discovery. And we need to resolve these issues of how these same issues can be decided twice without subjecting the estate and the parties and the court to the burden of two duplicative trials. Our position is that the easiest answer and much more logical answer is to have these issues decided in the context of the confirmation hearing.
Let me ask you a question, Mr. Harris. One of the things that is raised by Mr. Hughes's clients is that the debtors are continuing to engage in illegal activity through the price fixing and anti-competitive aspects of the claims involving Axar. Is that a confirmation issue, and how do I deal with that?
They have raised it as a confirmation issue because they have indicated that one of the elements of a confirmable plan is that the debtor is not engaged in illegal conduct. So they have raised that. I would say there is no evidence at all. They know extensively about the conduct that they allege to have participated in. They have gotten years of discovery to date. No regulator has said that we're engaging in illegal conduct. That is a fiction that they have created. So there's no basis for that. They can raise it at confirmation. I'm sure they will raise it at confirmation as they've raised it in sort of every context to date.
Okay. Thank you, Mr. Harris. Let me hear from the Axar plaintiffs.
Your Honor, may it please the court, good afternoon. Daniel Aston for Ciardi and Aston. My partner, Albert Ciardi, is going to handle the argument for the Axar plaintiffs.
All right, Mr. Ciardi.
Good afternoon, Your Honor. Thank you. As I think I had made clear in my letter responding to the debtor's letter, we are open and have always been open and would have been open if there was a pre-letter discussion on a new hearing date somewhat further out to allow a more fulsome discovery. We would love that. We would love to have had that discussion not in open court and before today in an appropriate meet and confirm. But we didn't have that. But what I think is misunderstood by the debtors, it is not that our trustee motion reiterates or simply restates a confirmation objection. What our trustee motion goes through and does is outlines severe infirmities in the plan which point to self-dealing. It points to inappropriate investigation of insider transfers to the tune of $14 billion, more than we raised in our motion, Your Honor. We've done a further analysis. Those issues point to the fact that this case, this plan, which hasn't changed at all since the RSA was drafted many months ago, hasn't changed at all since what was in their mind when they put the RSA together, when we were before Your Honor on exclusivity, when they promised a plan the end of March, and when we got it in April. So we refiled our motion when we saw the plan, because now we knew, in fact, that they weren't changing their position that was in the RSA, and that they were going to be giving all of the value of this entity to either the guaranteed unsecured notes, who are in no different a position than my clients, and to management. And one of the issues that we're raising in the motion is on valuation and allocation. And with regard to the investigation of the transfers, is the debtors have raised, and they have raised it in their response to the committee's 2004 motion, that, oh, there's nothing to see over here with the guaranteed unsecured notes. They're structurally senior to you. Well, that word doesn't exist anywhere in the bankruptcy code or the Uniform Commercial Code. And the reason they get to say that is because there have been $14 billion of transfers upstreamed from operating entities, which the debtors refuse to investigate or pursue. And then when they move that money upstream and put their patents and other things offshore in Dutch companies where we can't get to them, they then can turn around and say, oh, we gave the funded debt that money, you don't get it, and we're not going to pursue the transfers to bring all this back down. Structural seniority is no different than asset stripping with a fancy name. And that's what the trustee motion is going to investigate and clarify, Your Honor. And in fact, what we are able to do just on the debtor's own documents right now that we have possession of, we know that they have prepared a detailed presentation on intercompany transfers, because they say that at paragraph 57 of document number 1944. And they gave that to the committee. So this argument that somehow they're going to be creating all this new discovery to give to us, it already exists. They prepared, as detailed in their, again, in the response to the 2004 examination of the committee, a waterfall of all their valuations and allocations. They did that in February with the committee. We didn't get it until April. We have requested the backup for 30 days, still has been refused to be provided. That backup exists and it's available, and they can push a button and send it to us. So all of this, I guess, concern that we're going to be overburdening the debtors with all these new document requests, they exist, they're ready now, they've been shared with third parties, they are not privileged, and they should be provided, and they form the basis of the trustee motion, which details a debtor that sat around the table with the guaranteed unsecured notes, whacked up the company, left 10% for management, and that 10%, based upon the debtor's numbers in their plan supplement, is worth between $80 and $100 million. So they want to be able to go forward with a plan that gives the Actar plaintiffs basically nothing, a piece of $100 million, maybe, and gives the management more than that, gives creditors that are unsecured creditors just like that a 70% distribution. And all of that folds into our trustee motion, which shows that this debtor is operating in bad faith. And the fact that they are giving this distribution to management more than they're giving to the unsecured creditors right out of the gate. And that's not magical numbers that I came up with on my own, Your Honor. The plan says they're going to get 10%. I went to the plan supplement and it shows on the day of confirmation, there's value in shareholders' equity at the what we consider to be a low value of over $813 million. I can do that math. At the low value, it's $81 million. When you read the rest of the Guggenheim report, that number could be close to $1 billion, which would mean they're getting more. So we've got not only management getting more and self-dealing with no independent investigation, we've got asset stripping in order to promote the guaranteed unsecured notes. And we have all of this being done. Now they want to have us on an expedited track to get to confirmation, where we're going to get to confirmation. And at that point in time, the trustee motion is justice denied or delayed, however you want to look at it. If we don't get these issues addressed now that we have the facts, which is what's supporting the new motion, the facts in the debtor's plan supplement, the facts in the debtor's plan, the response to the 2004 motion. My targeted discovery, Your Honor, that we have asked for isn't overwhelming. I need Mr. Trudeau and Mr. O'Neill for the grand total of a day and a half or 2 days, and I'll make my case at a hearing before June 30th that this debtor has been engaged in asset stripping. So we think it would be appropriate. I would agree with the debtors, maybe not June 9th, but sometime before June 30th to have the hearing, to have a short targeted period of discovery beforehand and address all these issues. It's not a confirmation objection, Your Honor. It is using the plan to show the bad faith and self-dealing of the debtors and management. And that is what creates the need for a trustee here, because the Actar plaintiffs and every creditor on the specialty brand side of the business is being forced to bear the punishment of the specialty generics and management's decision to engage in an opioid scheme. And as a result, we're paying the price for their past sins. And they're not acknowledging that responsibility, and they want us to bear that cost. That's not fair. That's not appropriate. That's why a trustee needs to be appointed, even if just for specialty brands, so that a fair and reasonable plan that reflects the will of all the creditors can be addressed. And that's why, Your Honor, we do not want to, we do not agree and would not want this hearing to take place in August or whenever the debtors get around to putting together a plan that might go to confirmation. These issues need to be addressed now because they go to the good faith or lack of good faith of the debtors in presenting this, and they go right to the heart of trustee issues such as self-dealing, non-investigation of transfers, and just an unfair and unreasonable burden shifting from the ills of specialty generics and what management did there to what's going on with the Actar entities. And I want to focus now on what Your Honor's question was to Mr. Harris. Every day that goes by in this case, since the filing of the petition date, there have been deliveries of Actar gel to customers, to patients. They have all been done. There has been no change in conduct since the pre-petition conduct that survived 5 motions to dismiss at the district court level. So to the extent that there's a concern that whether our cases have merit, they do. They've survived 5 motions to dismiss and motions for reconsideration.
Well, Mr. Ciardi, a motion to dismiss, the court is only considered, is assuming that the facts alleged in the complaint are true. So that doesn't really show me that there's ultimately merit to the claims.
I
and I have no
understand.
ruling from any, I have no judgment from any court that says that the debtors have engaged in illegal activity. I have no investigation by the government that says they're continuing to engage in illegal activity, which the government could do if they choose. So, you know,
I'm sorry,
I spent a number of years. I spent a number of years in the military, and I can recognize a flanking maneuver when I see one. And it seems to me that this portion of the motion to appoint a trustee is really trying to outflank the automatic stay that's in place against the debtors to pursue claims that it's just not time to do that. This is not the time to pursue those claims. That will come at some point, but this is not the time.
Your Honor, I guess what I was going to is that this debtor is continuing to do things that we believe are violating the antitrust laws of the United States. And that conduct is illegal in our mind, and we think it's appropriate to be raised as a trustee motion because it should not be allowed to continue under the banner of being in Chapter 11 bankruptcy. And it's something that needs to be examined now to prevent further harm to my clients. Further financial and physical harm is being incurred on a daily basis to the patients that can't get access to this gel. That's not appropriate. That's not a proper use of Chapter 11. And while we
Well,
We are-
Mr. Ciardi, I have no evidence before me that anybody is being denied access to this drug. And I understand you want to litigate your claims, but as I said, this is not the time or place to do that. And if there's going to be a hearing on this issue as it relates to the appointment of the trustee, that's going to require discovery and probably, I don't know how many week-long trial, because I'd have to make an underlying determination on the validity of your claims that you've made against the debtors. And I can't do that. It's not going to happen between now and August or September, I can tell you that. I don't
Your
have
Honor,
time.
but Your Honor could address on a very short basis the fact that the debtors have made improper insider transfers to the tune of $14 billion, moved money away from where the general unsecured creditors can get them, refused to investigate or pursue those transfers because it benefits the guaranteed unsecured notes, which locks in a class that can vote in favor of a plan that gives management 10% of the company more than what's given to unsecured creditors. If you put the antitrust conspiracy aside, right down the center of the bankruptcy trustee rubric is that. And that could be addressed in 2 or 3 weeks or less with targeted discovery. And that issue should be addressed well before confirmation, because it goes to whether this debtor is capable of exercising its fiduciary duties to put forth a plan.
Well, the problem with that is those are all confirmation objections, which you have recognized. They're confirmation issues. And if I open up discovery on this outside the context in just a 2-week period, every other constituency in this case is going to want to participate in that discovery, because there's a risk that if I rule one way or the other, it's going to become law of the case. And now how are they going to then come to confirmation and make arguments when, based on a very limited, short discovery period, I'm making findings of fact about what the debtors did or didn't do? That seems unfair to every other constituency in this case.
Your Honor, I have to disagree for the following reason and on 2 points. Number one, if the debtors are engaged in self-dealing, whether we have to do it twice or 3 times, it still has to get done. The code requires us to have that investigation. But the second part of it is this debtor is burning tens of millions of dollars a month. If their plan is dead on arrival, and I'm not the only creditor I'm not representing the only group of creditors this time that believes that it's dead on arrival. We should know that now before we burn a whole lot of legal fees in daylight in going to try to get something approved to send out to creditors that has no hope of ever getting approved. This will save the estate.
What do you, Mr. Ciardi, what do you think it's going to cost if I ruled that a trustee should be appointed? How would that affect this case? A trustee comes in, has to start over from scratch, and this whole case starts over again.
Your Honor, if the case...
Is that efficient rather than dealing with these issues at the time of confirmation, along with confirmation, and anyone who objects to confirmation can do that. There will be discovery on the confirmation issues. The debtors have recognized that, and they're willing to go forward with that discovery, just not doing it on a 2-week or even 3 or 4 week basis. The amount of discovery that needs to be done and the effect that it has on every other constituency in this case is what is most concerning to me.
But Your Honor, if that, and we believe that it is true, if this debtor has engaged in self-dealing and that the documents that we believe discovery will bear out will show that this plan that they implemented under the RSA was meant to protect the guaranteed unsecured notes and management at the expense of the general unsecured creditors, of which we are a part, then that has to be addressed now. Whether that has $1 billion effect on value, $1 million effect on value, we believe it will have a tremendous increase in value, because instead of the specialty brands having to bear the price of the opioid mistakes of management, the specialty brands creditors will be able to recover more under a trustee than they are now. Right now, we're getting nothing. We're getting less than management. If we're getting the value of the Actar brand entities, which is all that's really left in this company, we can create a plan, or a trustee could put a plan together that generates a much larger distribution for unsecured creditors than what's currently being offered now, which is 2.5%. That's what they're offering guaranteed or general unsecured creditors now. What they're offering the guaranteed unsecured notes is close to 70%, and they're only doing it by this structural seniority, which is only happening because they were able to move assets out of those entities. And that has to be changed. That has to be reversed, Judge, because if it doesn't, and we get to confirmation, and we've wasted another 4 months of time to get there, and then the trustee has to start, that is a waste of judicial resources. And it's another 4 months that my clients have been punished physically and financially by the debtor's conduct. And that's just not fair. And if Your Honor is considering moving it to that, I'm going to go with the phrase that has been, that we all learned in law school: justice delayed is justice denied. And that's where we are if this trustee motion gets moved to confirmation. Thank you, Your Honor.
All right. Does anyone, before I go back to Mr. Harris, does anyone else wish to speak? And if you would, I'm not sure what happened to my screen here, but usually everybody who is on video appears on page 1, but right now everybody's scattered all over the place. So if there's anyone who wants to speak in support of the trustee motion, please raise your hand.
Your Honor, Don Havlin, I wanted to speak to the discovery issue that was raised by Mr. Harris, and the fact that our discovery propounded cuts across not just the trustee issues, but also the issues raised by the debtors by their April 30th filings. Your Honor said that the issues goes to the validities of the claims. The debtors filed 2 objections and have asked to have those decided in the first week of June. Now, we met and conferred at length yesterday over the various corporate designee depositions, Trudeau, O'Neill, and one other individual deposition, and we were told none of that was going to happen. We were told that the debtors were unwilling to move off their objection to what they call the Actar plaintiffs', quote, unsubstantiated claims, close quote. They are challenging the validity of the Actar plaintiffs' claims. And I want to point out, Judge, we are the only group of unsecured creditors that are getting this favoritism. We have these substantive objections to our 400 proofs of claim. We're being told you get no discovery, and why it intersects with the trustee issues is we have made claims against these specialty brands, mallinckrodt entities, to whom they transferred billions of dollars to leave a shell at the mallinckrodt ARD company, which is the company in charge of the Actar business, $1 billion a year business. So it does go to the heart of the matter, Judge. On June the 7th, because the debtors are unwilling to move that hearing date, you're going to hear me speak again about all the discovery we didn't get. You're going to hear the debtors argue that you should rule in a vacuum, that we shouldn't get to understand how billions of dollars can be moved out of a company we sued into a company we didn't sue, and why we should not be able to make a claim in bankruptcy against that entity. Now, Mr. Harris just glossed over a whole bunch of discovery. He said they produced hundreds of thousands of documents to us. Well, that may be true in the purest sense of the word, Judge, but what they did was they reproduced to the Actar plaintiffs a subset of the documents that were produced to the plaintiffs over 5 million pages in the underlying litigation. That's not discovery. That was discovery given to the committees, which is a subset of the discovery we asked for. The sum total of what they've given us is one chart that talks to these subsidiary entities, who they are, and it helpfully demarcates them as brand entities and generic entities, so that we now know that in the 64 entities that Mr. Welch spoke about on the first day of hearings, which are brand and which are generics. But that's just the first inquiry. One document, that's what we got. One document, no witness. We do know from the schedules and statements about these money moves, but we don't know how, why, or where they were sent and whether or not that money was appropriately moved. And that's the heart of the issue in terms of claims. And the debtors want to have you rule on claims, the validity of claims on June the 7th. Separately, they have filed an adversary proceeding saying that there should be a discharge of the Rockford plaintiff's claims, a complaint for discharge, an adversary. We have opposed that with a Rule 56D affidavit, which goes into great detail about the discovery that we will need in order to defend the complaint. The defendants have yet to commit to any discovery. In fact, had the audacity to notice the deposition of the lawyer who did the 56D affidavit. And they're aggressively seeking discovery in 7 days or less of the Actar plaintiffs. We get no discovery, they get discovery in 7 days. And you're going to see motions practice, Judge, because I don't know anyone that's going to be prepared for a corporate designee deposition on Tuesday after the long holiday. But that adversary proceeding has a summary judgment motion component to it. They filed the complaint and summary judgment on the same day. And I know Your Honor had a conference with Mr. Aston and counsel about this, and we told the court that we were going to put forward an affidavit to point out the discovery that needed to be taken. What we've tried to do is give the debtor various corporate designee notices with topics. The debtor is still coming back with proposals, but has yet to commit to one witness on one day to answer those topics. We have not gotten any discovery. And so the suggestion Your Honor made about being concerned about discovery, coordinating discovery, we proposed that to the debtors, but we're being told no, that their agenda will dictate. They will get their hearings on June the 7th, the 8th, and the 9th, but all of our issues we're going to get put off to another day. And Judge, it's going to come to a head. You're going to see this come to a heading on the 7th, when I have no discovery and they say just dismiss these claims that were validly filed and are validly constituted, because unlike any other claimant, we attached complaints, documentation of damages, and actual documents, so much so that there was a motion to seal every one of our claims, and now they're not even publicly available to anybody. But to Your Honor's point about the continuing conduct, I have to point out that the Federal Trade Commission filed a complaint against this company and got a declaratory and injunctive component through a stipulated settlement with this company to not continue to do things. We believe they're violating that. So the government did prosecute in 2017, and that's why Rockford sued. Secondly, the Department of Justice, a different arm of the federal government, has prosecuted this company for marketing fraud in Philadelphia. That case remains pending. Local 420 filed a companion suit. The United States Congress issued a report on October 1 of 2020, where these executives testified and detailed fraudulent conduct. And nowhere did any one of those congressional committees, the FTC or the DOJ, say that this company had stopped. The debtor likes to say, well, no one compelled them to stop. That's what the civil plaintiffs' lawsuits are doing. We have a declaratory and injunctive component in Rockford, Local 420, and every one of our complaints. They have not stopped, and you don't have to take my word for it, Judge. Mr. Welch and Mr. Reasons, as corporate designees, testified under oath in direct questioning, have you changed the underlying conduct? They said no. In this record, no. That's the evidence. We're arguing about scheduling, but that's the evidence. And we're going to go forward to prove that at the appropriate time. But Judge, to finish what Mr. Ciardi pointed out, we're perfectly willing to coordinate scheduling. We had an original deposition notice of Mr. O'Neill and Mr. Trudeau, as Your Honor remembers at the first hearing I had with you. It was an emergency motion to put that off. And we agreed to that. But the issue then was whether or not there'd be a breathing spell, whether or not these executives would get time to focus. Well, it's been almost 8 months. So we've noticed those depositions. This is the first we're hearing, by the way, that others want to take those executives. Fine, let's coordinate a date. I'm not suggesting it has to be next week, but it has to be next week if we're going to have a hearing on June 7th, because those depositions go to our defense of their motions. So perhaps we should have a coordinated discussion with everybody about scheduling. and put off the June 7th, the June 8th, and the June 9th schedule that the debtors are rushing. They started on April 30th with these motions. We call them the Friday night filings because they literally came at 11 to midnight on Friday night. And we had to scramble the next week to respond. We, the Actar plaintiffs, are getting all this attention, Judge, but we're getting no discovery. And at some point in time, due process is going to have to come into this case. We're going to have to get some discovery so we can defend what this company is saying about our claims. Or we'll just go to a hearing and you'll dismiss them. I suppose that's what they want, in which case they should just ask you to rule today. Why go through the process?
All right. Mr. Harris, I can't find you on my screen. Can you raise your hand, please?
Yes, sorry, Your Honor.
There we
You see
go.
now?
Okay.
Thank you, Your Honor.
Go ahead.
I'll be brief on the points Mr. Ciardi made. I would just say everything you heard is what I said you would hear, which is those are admittedly plan confirmation issues. All of those issues he raised are plan confirmation issues. The extent that there is an argument about patent unconfirmability, we have a disclosure statement hearing on June 8th that will address that. In terms of his suggestion that we just heard today that we carve off just one of the many issues he raised and just look at litigating intercompany transfers, it's not that simple. He may think that these transfers that he's talking about were out of ARD were inappropriate, but there's creditors on the other side of mallinckrodt who will think that they were appropriate and don't want value to be transferred that way. And they are challenging their own transfers to ARD. The other creditors have made their own arguments about intercompany transfers. There is no way to isolate just one intercompany transfer and address whether that makes our plan patently unconfirmable in 2 weeks without every creditor wanting to step in, have their transfers addressed as well, and have a full resolution on this. So the point is the same for every one of these issues. They cannot be hived off and done easily. In terms of cost, there's no way that having a separate duplicative trustee discovery process in motion is going to reduce costs. It is just going to duplicate them. In terms of what you heard from Mr. Haviland about discovery, he is talking about a different contested matter. He's talking about discovery on the debtor's unsubstantiated omnibus claims objection. I don't know why we're discussing that today, but just to correct the record, we have provided over 100 emails. We provided dozens of organization charts. We provided dozens of intercompany agreements. We have provided every document that was produced under Rule 2004 to the committees. And to be clear, as I said, there are other requests which we think go beyond the scope of that objection. We have said we will consider and produce in the context of confirmation discovery to the extent relevant. So we've never said no. We have provided discovery. We will continue to provide discovery. But what they're asking for the trustee motion is enormous, entirely duplicative with confirmation discovery, and needs to be coordinated with it. Unless the court has more questions, that's all I have.
No, I don't have any questions. So the only issue before me today is the scheduling issue. Do I move the hearing on the trustee motion to confirmation, or do I leave it where it is, or pick some other date in between? Given the issues that are involved in the trustee motion, which predominantly appear to be issues involving confirmation, which every single constituency and creditor in this case is going to be interested in, and trying to conduct that discovery and have a hearing on June 9th is simply something that can't be done. There's just not enough time to do that. And it would be prejudicial to all the parties in this case, not just the debtors, but all the other constituencies in this case are going to be prejudiced if we have to do this two-step process of a trustee motion and then a confirmation objection. A lot of this is going to get fleshed out at the disclosure statement hearing. Parties have already filed objections to the disclosure statement, and those are going to have to be dealt with at that hearing. So given that I think preserving the resources of both the estate and this court, it makes more sense to have the trustee motion heard at the time of confirmation hearing. It's more efficient. It reduces the discovery burden on everybody, and it just makes more sense from a practical standpoint to do it that way. If it turns out that the debtor's confirmation hearing is denied, or confirmation is denied at that hearing, then there's issues about whether the trustee should be appointed at that point. And I think that makes it more efficient as well. So based on what I've heard and the issues that are involved, I am going to grant I'm going to assume this was a motion to continue the trustee hearing, and I'm going to continue it to the date of the confirmation hearing. And the parties obviously are going to have to continue to discuss, coordinate with issues involving discovery, and the debtors should do that with everybody involved in the case, anybody who wants discovery on these issues, and provide the discovery in as timely a fashion as is possible under the circumstances. Are there any questions?
No, Your Honor.
Mr. Chiardi?
Yes, Your Honor. The question is, so Your Honor will be entering an order today that adjourns this hearing on an unscheduled basis to whenever the debtors may or may not have confirmation.
That's right.
If the disclosure statement is not approved next week, then there's nothing pending.
Well, then we will have a status conference at that point.
Then could this hearing be adjourned to that date and then address scheduling at that date?
Mr. Harris?
But, Your Honor, there's no need to adjourn the hearing if in fact the disclosure statement is not approved. We can have another discussion on this in terms of scheduling, when that issue arises. But I think the appropriate thing is right now to schedule it to be to be at the same time as the confirmation hearing.
Your Honor, there is no confirmation hearing.
Well, I understand that. But I am going to enter an order today, and I'm going to ask the debtors to prepare a form of order that moves the trustee motion to a date to be determined at the time of confirmation. I will also set a status conference. When is our disclosure statement hearing?
June 8th, Your Honor.
I will set a status conference on the trustee motion for, my calendar's jammed. We'll set it for June 14th at 11 a.m.
And Your Honor, how will this affect their response date?
Your Honor, I would propose it be coordinated with whatever response date is set for a confirmation. Since it's the same issues, it should be, a response date could be at the same time as on the confirmation schedule.
Your Honor, that would be unfair. That would be unfair to the actor plaintiffs. How will we know what discovery we need to take in the interim without their answer?
No, that's a valid point, Mr. Harris. How do they know what discovery to take until they see what your response is?
Well, they already served discovery without seeing our response, so I don't fully understand that complaint. They've indicated they already know the issues that they're interested in. They've served discovery on them. They're very detailed. They can serve additional discovery. They don't need our objection to serve discovery. That's not how confirmation normally proceeds, and these issues don't normally proceed, which are confirmation issues by the debtors objecting and then discovery taking place. It's sort of the opposite process normally.
Your Honor, the actor plaintiffs have raised serious issues of self-dealing, mismanagement, fraudulent transfer. The debtor needs to step up and put an answer on the record that affirmatively denies or admits that conduct so that we then know how to move forward with regard to our discovery and preparing for a hearing. It's unfair to adjourn us to some date in the future and give them an open-ended answer date. They should have to answer as within the next 10 to 15 days. They clearly think it's frivolous, so an answer should be very easy to do. And then we'll know what we need to take in discovery and what may be admitted or denied. But then they will have answered these allegations, which they should be doing on June 9th or June 25th or whatever. I understand Your Honor's ruled to move them on to a date that's in uncertain future, but they should answer in a document that's filed with the court so that people can examine how they choose to respond. That's an important thing for the bankruptcy system.
All right. Well, for now, I'm going to leave that open. We'll put that on the agenda for the status conference that we hold on June 14th as to when the response date will be, because it will be informed by what happens during the disclosure statement hearing. So for now, Mr. Harris, the order should be that the hearing on the trustee motion is continued to a date to be determined in conjunction with plan confirmation, that there will be a status conference on June 14th at 11, and that as a part of that status conference will be the issue of when the debtors need to file a response to the trustee motion.
Understood, Your Honor.
Anything else for today?
Nothing additional, Your Honor.
Okay. All right. Thank you, everybody. We have a holiday weekend coming up. I'm not sure. Hopefully, everybody can enjoy it. I know there's a lot coming up in the next couple of weeks, so I'm sure everybody's going to be busy. But I hope you can at least take some time off to spend with your family. So enjoy the holiday weekend, and I will see everybody soon. We are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.